A man convicted of child abuse and the death of his girlfriend's daughter may get a new trial.
Leo Ackley is serving a life term with no chance for parole in the death of Bailey Stenman. But his lawyer did miss getting key witnesses that could have exonerated him at trial. 24 Hour News 8's Joe LaFurge is here with the story.
Yeah, Brian, well, that's the main question before the courts. Ackley's current attorney says some in the medical community are changing their opinion on whether evidence of child abuse or shaken baby syndrome is always correct. He says Ackley's trial attorney should have done more to raise that issue at trial.
He's very happy. He knows. He knows he didn't do anything.
Linda Bird on the reaction from her son, Leo Ackley, after learning Calhoun County's chief circuit court judge ruled Ackley should get a new trial. Ineffective counsel was a legal issue, but the growing debate over whether an expert witness can determine when a child dies as a result of abuse, usually referred to as shaken baby syndrome, is at the heart of the new defense argument.
It's now gaining traction. More and more forensic pathologists are looking at this and questioning the science, because it's very difficult to determine how much force it takes to kill a child.
The judge agreed that argument should have been heard, that Leo Ackley's original attorney should have sought out experts to counter the prosecution expert who testified Bailey died as a result of a traumatic blow to the head. The girl died in August of 2011 after Ackley claimed she fell from her bed. Ackley's appellate team called on Dr. Warner Spitz, a well-known pathologist out of Detroit, to look at the case.
Based upon his training and experience, he determined that Bailey Stenman's death was likely caused as a result of an accidental fall, some type of short fall injury.
Prosecutors like to avoid questioning a judge's opinion when it goes against them, and Calhoun County Prosecutor David Gilbert is no different. He did tell me he will appeal the judge's ruling. The defense still has an uphill climb. They need a ruling from the State Court of Appeals to get a new trial. Then they'll need their expert witness to put doubt in the minds of a jury.
There have been cases where the prosecution has declined to prosecute after being presented with this evidence. I'm not aware of any local cases, and we are hoping to establish at least a local precedent.
Roy now says he expects the Court of Appeals to schedule arguments in the next 42 days.